Hello, I'm Chai Hafilenia. Welcome to Talk Thursday. Kicking off what may prove to be a historical judicial case, the Ombudsman filed plunder cases against three senators, Juan Ponce Enrile, Ramon Revilla Jr., and Jinggoy Estrada, along with businesswoman Janet Napoles. This was for their alleged involvement in the multi-billion peso pork barrel scam. Revilla and Estrada are now detained in Camp Crame. Police authorities have also said they are ready for a possible hospital arrest for Juan Ponce Enrile, who is 90 years old. What comes next? Human rights lawyer Chel Jokno will walk us through the judicial process and what is in store for the next few months and possibly even the next few years. Good afternoon, Chel.
Good afternoon.
Thank you for making time for us.
Sure.
I'd like to start off with the Plunder case. You were involved in the ERA Plunder case as well. Do you see any similarities or parallelisms with this particular Plunder case?
Well, I wasn't involved in the Plunder case per se. I was involved in the impeachment, although I did monitor the ERA Plunder case. Of course, there are some similarities between that case and this case. Both came out from a Senate investigation. But if you look at the facts that from which they arise, they really are very different. Of course, another similarity probably is that there were whistleblowers in both occasions. But beyond that, as far as the prosecution of the case is concerned, I think the Ombudsman really has to get their act together and make sure that they deliver the goods.
What are given the recent developments in the case and the moves to make amendments in the information that had been filed, what do you think would be the implication of this?
Well, the Ombudsman has to consider as well not just the court battle itself, but even the battle for public opinion. Their recent actions have not exactly enhanced their credibility to the public and have raised a lot of questions about how effectively they can prosecute the case. But I think what has happened recently is an offshoot of the structural problems within the Office of the Ombudsman. For a long time, and up to now, the unit within the Ombudsman that prepares the information and conducts the preliminary investigation is a different unit from the prosecutors who actually handle the trial, who present the evidence. So the prosecutors who are tasked with conducting the trial, basically they receive the information, and as from what I understand, they don't have any input in how it was prepared.
So there's a disconnect between those who actually go and prosecute.
No,
and those who
I
prepare
don't
the
know
information.
what happened in this particular case, but I suspect that when the trial prosecutors received the original information and looked at it, they said they weren't happy with the contents, the allegations. So they said, we have to amend this information. And this is not the first time that has happened. I've had a number of other cases where same thing has taken place.
So this has been going on for several years now?
Yes, I've been conducting training of ombudsman lawyers since around 2005. And I've been hearing the same complaint ever since.
But why is that? I mean, this is such a big case. It's a major case. And yet they did not confer with each other before they actually filed the information. Isn't that problematic?
I'm not sure what was done or how the team was organized. It would have been ideal if the team was a cross-section from different units within the Office of the Ombudsman to make sure that they covered all the bases. But as I understand it, it's very territorial. So if I'm the guy who's supposed to prosecute this case, that's my job. I don't have any involvement in the
That's crazy.
Yeah, it is crazy, especially for a big case like this.
So you recommend that the Office of the Ombudsman revisit this structure and
They should.
and
They
quickly
should.
adjust.
They should. The other problem that I saw is that if you read the motion of the prosecution to amend the information, the motion is pretty well drafted and it covers all the grounds needed. But to what extent was it argued and how well was it argued during the actual court hearing? From what I gather, I wasn't there, but from what I gather, the prosecutors simply sort of bowed down submissively to what the justices were telling them. which was very different actually, which was the opposite of what they had alleged in their motion. Part of our job when we appear in court is if we file a motion, we argue it to the best of our ability and we insist on it. And if the court doesn't agree with us, then we ask for reconsideration. If it's denied, we elevate the whole matter to the Supreme Court.
In the case of Jinggoy, I think the justice who was involved there said that he spelled it out. He said that are you sure you want to change the information, because one consequence of that is that the arrest warrant would be lifted and they can be set free.
That's the point that should have been argued by the prosecution. I disagree with the statement that they would have to go free. If the amendment changes the charge, let's say from murder to homicide or to another crime, if you remove people from among the accused, then that would be the consequence. But the amendments here are not like that.
So the amendments are not substantial because, for example, I took note of 2 points that they raised. One was deleting the phrase enabling Napoles to misappropriate the PDAF proceeds for her personal gain, which means shifting the focus from Napoles to the senator.
Well, let me correct that a bit and clarify. Before the accused are arraigned in a criminal case, the prosecution has full control of the information, and they can amend the information, whether in substance or not, on their own as a matter of right before arraignment.
So that's critical before arraignment.
Before arraignment. The motion in these cases now were all filed before arraignment, as far as I know. So therefore, the general rule is the court is bound to accept the amended information. The only time that the court will have to, when the court accepts the amended information, they will have to analyze it and say, will this require a new preliminary investigation? If new evidence is presented, if it's a new charge, then that definitely requires a new preliminary investigation. But if you compare the amended and the original informations here, it's still based on the same evidence. It's still a charge of plunder. So there may have been substantial amendments, but before arraignment, they are
That's
allowed.
fine.
After arraignment, you can no longer have substantial amendments.
So the prosecutor shouldn't have buckled down.
One of the things I tell all my students is when you go to court, you stand your ground. When you go to court, you never back down. If you file something, that means that you have absolute conviction that that's the right thing to do. So why, when you go to court, suddenly you'll surrender to the justice? I don't think that's the right way to handle things.
The other point that was raised was the use of the phrase in connivance and in conspiracy.
In collaboration.
Is there a difference between that? Conspiracy and collaboration or connivance?
The rules and the decisions require that if you're going to make a claim of conspiracy, it has to be alleged in the information. It doesn't necessarily require that you use the word conspiracy, but in actual practice, 99.9 times when you have a case of conspiracy, you have to see the word conspiracy within the charge, within the information. I don't understand why the prosecution in the amended information, which wasn't accepted, wanted to change it from conspiring to collaborating. Because that's not clarifying it. That is making it a little bit more confusing.
And is there a difference? I mean, legally, is in terms
There's
of
a legal definition of conspiracy. There's no counterpart legal definition for collaboration as a means of criminal complicity. There's only a definition for collaboration, let's say in war and things like that, but not when it comes to criminal.
But in conspiracy, they say that the fault of one is the fault of all. So that has to be
precisely. If the amended information had been accepted, probably the defense then would have said, well, you cannot prove conspiracy because you didn't allege it, because in the amended it says collaborating.
What would you say about the quality of prosecutors? You said earlier that you've been training them, you've been working with the Office of the Ombudsman, and I know that years ago, I think the conviction rate of the Ombudsman was pretty low. I think as low as 3%, if I remember correctly. Do you think they are ready to do battle with very, very veteran lawyers like Flaminiano and Estelito Mendoza?
Let's just say that they are at a tremendous disadvantage. both in terms of skills and in terms of resources. Unfortunately, the best of our litigators never end up in government. The best of our litigators, most of them end up in private firms, especially the bigger firms. You hardly, nowadays, you don't find that many public prosecutors who are really effective trial lawyers. Well, generally, I'd say in the whole bar in this country, there really are very few good litigators, and most of them are in the private field. So when you have a case like this, the senators, of course, will be getting the best lawyers that they can get. That immediately puts the prosecution at a disadvantage.
Should we start worrying then?
I think that we should start watching and making sure that the government does its job in this case. It's too important to just leave it to them. And in my experience, if you leave it to them, things bad happen or could happen.
In the Arab impeachment case, I think there were private prosecutors who were brought in. Is that something that the ombudsman should think about?
Perhaps the ombudsman should think of that very carefully. As I recall, in the Arab Plunder case, there were also lawyers who were in the government but not within the office of the ombudsman, who were deputized to assist. Because there are a lot of good prosecutors, for example, in the Department of Justice. Yun talagang marunong maghawak ng kaso. I would say there are more seasoned litigators in the DOJ than there are in the office of the ombudsman at present.
What do you expect will the defense lawyers try to do?
Everything.
Such
I'm
as?
sure they will try everything. Every misstep of the prosecution, they will try to take advantage of. And they're expert at it. They know this game. They know the business of handling
So what are the
case.
things that we should be watching out for?
Well, one is cases are not won inside the courtroom as much as in preparation. I am hoping that the Ombudsman's office is preparing its witnesses carefully and the exhibits that they will be presenting. It's very technical, but if they fail, for example, to authenticate all those records of Ben-Hur Loy,
Yes.
that case will crumble just on the fact that they were unable to authenticate evidence. So this, and if the testimonies of the witnesses vary greatly from what they said, let's say in the Senate, again, that will be exploited by the defense.
We've seen some of the files of Ben-Hur, and we noticed that some of them had deletions, and some sheets had figures, names that have been that were probably there and then were eventually taken out. Would this weaken the prosecution? If this is what the basis of the
I expect the
prosecution
defense
would be?
will attack that, but the biggest obstacle really for the prosecution is the fact that Loy and the rest of the whistleblowers can only testify to what they know. But were they there when, for example, transactions were made with the principal accused, with the senators? If all that Loy can testify to are the records, but not the meetings or money changing hands or the plan being made, what evidence will the prosecution use to implicate the
So everything will be
senators?
hearsay on his part?
Technically, that would be hearsay.
If that is the case, then wouldn't the prosecution then need Janet Napoles?
Maybe her or somebody like her who has the personal knowledge to say that, yes, this senator so-and-so did this or did that. I don't know if Loy and the others can say that.
I don't think they were involved directly.
If that's the case, and that should have been obvious from the start, then the job of the prosecution would be, in addition to having these witnesses, finding other witnesses who could now supply that. The one, of course, who would come to mind naturally would be Janet Napoles, but
Yes.
of course the government has issues as well about making her a state witness.
I see a dilemma for the prosecutors here, because if her testimony would be central, because she's the one who had direct dealings with the senators, then they need her. But at the same time, she's not exactly the least guilty, which is a requirement for being state witness.
Well, the requirement, if I recall, is not the most guilty, which
Yes,
is
yeah,
different
yeah.
from being the least guilty. And if it's not the most guilty, it depends on whether she's the mastermind or not.
Could that be the reason why they also tried to change the wording, saying that she did not do it for personal gain, and
That would explain.
she's not the main
That would explain.
character?
The question now is if that analysis is true, why only now? That case has been with the Ombudsman for some time. We would have seen the legal situation easily from an analysis of the records. Then they would have realized we need to get some other witness as well. And in which case, when they filed already the case, that would have been very clear in their mind. Who is going to be the mastermind? Who will be the, what's going to be our theory for the case?
So obviously, do you agree, because the public perception also is that everything was rushed, the preparation of the information and the filing of the information?
Maybe it was rushed. I really don't know, but definitely it was not given enough careful consideration. If it had, then there would have been no need to amend the information. From the filing, it would have been all, the allegations would have been sufficient. Go on with the case.
There have also been concerns raised about double standard now, because the senators, at least the two who have been issued warrants of arrest, are in a custodial center, and the facilities are much better compared to the ordinary facilities that ordinary folks would be put in. Should that be changed? Should they be moved to less less ideal facilities, or should it be the other way around? Should our jails be or our detention centers be improved?
Oh, we have a tremendous problem with our jails. I've been to a lot of jails in our country. I've never seen a jail that meets minimum standards of the United Nations. So I understand why some judges are, sometimes lenient when it comes to prominent people charged in their court. But you're right, I think, to bring out that issue. There's really two related issues there. One is the hospital arrest, or the proposed hospital arrest for Senator Enrile. Second is the fact that the two other senators are being kept in custodial center. That stockade in Camp Crame, among us lawyers who have had a lot of cases, para sa amin, parang 3-star hotel yan. Yeah. Because when you go there, it's really intended for so-called big-time personalities. And there have been questions were already raised before. If you recall the case of Mayor Sanchez, doon din siya nakakulong noon. And if I recall, issues were also raised at the time. Why is he being put there and not in a regular jail? And whenever you have issues like that, the public will always have that perception that people who are big in society get treated differently. They
Double
get better
standard
treated.
talaga, which should be changed.
Yeah,
but
that
in
should be
reality, it's difficult to do that.
The judges, I think, have to work within the existing situation. They know, for example, if the centers were to be put in Manila City Jail, they know that there would be super problems with security, problems even with the health of the persons involved, etc. They're thinking of that, I think.
Can't lawyers question that? I mean, if you know, for example, that it's very blatant na double standard nga, can't there be a clamor to put them elsewhere?
Yes, and probably there should be. But at the same time, I think the legal profession would do this country a big service if we pushed for reforms in prison. Because that is an issue that has been, people have ignored for the longest time, but we have to address it at some point.
Do you see a role for citizens, for ordinary Filipinos? The Plunder case strikes a very strikes a chord among ordinary Pinoys because of the amount of money that's that's involved. But at the same time, because they keep on hearing the same amounts, parang parang jaded na rin. What do you think either civil society groups can do, or ordinary, or students even? What can they do to watch these cases?
Law students in particular can do a lot. In the De La Salle College of Law, we just created actually a team of law students and myself and some professors that will keep an eye on the case. We're concerned primarily because of the issue of accountability. And we want to know if the government really is bringing in a good case.
When you say keep an eye, what exactly does that entail?
Going over the records, analyzing the pleadings and the motions filed, observing if we can the court hearings. That's the only way to know really if a case is going well or not.
How about the justices involved? Is there monitoring, or is there profiling?
Not necessarily profiling, but of course, since they'll be conducting the hearings, they will be part of our evaluation as well.
The senators have also been suspended, and I think the Plunder law says it should be automatic. For how long will they be suspended, and what does that mean when they're suspended?
I'm not sure of the period. I don't recall right now if the Plunder law provided for a different period. The usual period is 90 days suspension. In their case, I can't really recall. Your second question was?
I was just asking whether there's a length of time, and whether this would have an impact also on what it would mean. Does it mean if when they're suspended, they would not be receiving their salary, they cannot function as senators?
They cannot function. I'm not sure about their salary. I think they still receive their salary because they're still employed. The whole purpose of suspension is so that they cannot use their office to influence the case, so on and so forth. Although in their situation, the fact that they're senators, whether they're suspended or not, if they want to influence, I guess they could try.
And how do we make the courts less vulnerable to political pressure? Precisely because it's senators, very high-profile senators, who are involved here.
That's a question that I could answer for an hour and never finish answering. Maybe if you can rephrase it, I'll find a way to answer it in a short.
How do you make justices less? How do you insulate the court, the Sandigan Bayan justices?
Unfortunately,
from politicians.
It's the most difficult thing really is the fact that all justices want advancement in their career. So if I'm a justice of the Sandigan Bayan, I would probably want to be promoted or appointed to the Court of Appeals or the Supreme Court. And historically, justices who handle big cases, prominent cases, do get appointed to the higher courts. And that poses a problem in terms of finding justice in a particular case, because then they may be tempted to overlook the evidence perhaps and do what they think would be favorable to the people on top, just so that they'll get appointed to a higher position. That's always a factor that we look into when we handle cases. On the other hand, what's the best way to counteract that? I think the public has to be very much involved in the case. The minute the justices know that the public's not interested anymore, then maybe they will feel less reluctance to do something like that. But as long as everyone is monitoring it, then I think they'll keep in line.
One specific case comes to mind, the case of Nani Perez, former Justice Secretary. It was long running, and then it was dismissed on technical grounds because there was failure on the part of the prosecution to file certain information, I guess, or in response to what the court was asking for. And this can happen again.
Yeah, it's the case of Nani Perez is just one of a number of cases I know about.
But can the justice involved just get away with it? Can it be very whimsical?
Well, the question is, where was the problem there? Was it the lack of evidence submitted by the prosecution? Because even if the court wants to do justice, but if there's not enough evidence, they have no case. I'll give you an example outside of the Sandigan Bayan. Let's say you have a case of a big catch of drugs that was seized. Cases were filed. But when the case reaches the court, the arresting officer suddenly hedges and says, I'm not sure if that's the right tag, and then suddenly the drugs are not there anymore. Even if the court wants to convict, how can they convict if you don't have the testimony and the evidence?
So we should be watching the prosecutors as well.
It's much easier actually to evaluate the work of a judge, because you just look at what evidence was presented, then you can tell if the ruling was right or not. But with the prosecution, you may not know what evidence was not presented. In other words, let's say in the case of Nani Perez, who knows, maybe there were witnesses who should have been presented but were never presented. In which case, that's the shortcoming of the prosecution, not the court.
And if that is the case, who runs after them?
That's the problem. I don't think there is a system for holding them accountable, either within the ombudsman or even outside.
So there's no accountability on the part of the public prosecutors?
Ironically, they're from the office of the ombudsman, so they should be the most accountable. But for example, the case of Nani Perez, I haven't heard of any of them, the prosecutors of any evaluation even being done, if the problem was with them or not. The cases that I know where the prosecution bungled, as far as I know, none of them were ever held charged or held accountable.
Okay, in this, going back to the present cases, how do you foresee the prosecution, public prosecutors working possibly with the private prosecutors who might be brought in? How does that work?
I think that they would benefit a lot if private prosecutors got involved in the case.
Why?
Because the mechanics of conducting a trial, sad to say, I would have more confidence in the private prosecutors than with the public prosecutors. Questioning witnesses, these things, that's an art. And unfortunately, in the prosecution service, you don't find many of them who are familiar with it. Just simply asking the proper question. When you present a witness, you are supposed to ask only open-ended questions, not leading questions, who, what, when, where, how, why, and which. But I find that some prosecutors don't even know how to ask an open-ended question. When they're presenting a witness, they end up asking leading questions, even if they know that those questions are not allowed. So when you have problems with something as basic as that, you cannot leave them to work on their own. They have to have support.
And how many do you think would be needed?
I'll without mentioning any names, I'll tell you one that I had. I had a case of mine where although I was not the prosecutor presenting the witness, I prepared the Q&A, because I was concerned that if I left it to the prosecutor, he wouldn't know what to ask and would probably end up asking the wrong things. And ironically, afterward, I was even thanked by that prosecutor for making his Q&A.
That's very worrisome, Chel.
So, I'm telling you.
And how long do you think will this case drag on?
It will take years. In the first place, Plunder is one of the hardest cases to prosecute. Because of the elements, the evidence, the requirements. It's very hard to prosecute. And then you have a number of accused involved. They all have their own lawyers. Each of those lawyers will probably elevate this to the Supreme Court at some point in time. You can predict it'll easily take a number of years.
Jinggoy said that chances are he would also be acquitted here, just like the previous Plunder case filed against him. He's probably speaking from experience.
A lot depends on what evidence is really put on the record. At this point, although now the ombudsman is tied now to the original information, so because they haven't brought it up, they will have to live with that. But they still have so much room in terms of witnesses and evidence. They are not bound only by what was presented during the preliminary investigation. So if they have other witnesses, they could put them on.
So what will happen after arraignment? What's next, process-wise?
Pre-trial, after the arraignment, then the trial itself. Of course, the prosecution will present evidence first. And the defense may, if they think that the prosecution hasn't met its burden, they may file a demurrer. If that's not granted, then they will have to present evidence.
And how long will that take?
I can easily say it's not going to take a year. It's going to take much longer than that. The pre-trial won't take long, probably maybe 1 or 2 hearings. The prosecution's evidence will last. They would need maybe, 10, 15? I don't really know how many hearings they would need. I'm talking about hearings that don't get postponed.
Yeah.
And I don't know if the Sandigan Bayan is prepared to conduct this trial on a daily basis. Do you know if they've made any announcements?
No announcements.
If they're not going to do it on a daily basis, even if they do it on a weekly basis, it's going to take a long time.
The ombudsman had asked for a special court, special divisions, just to focus on the cases. Do you think this is a good idea?
I think the existing divisions of the court are enough to handle these cases. I suspect that there may be issues there that aren't really on the merits, but maybe have to do with the compositions of the different divisions. I can't really say anything beyond that.
But wouldn't it also put at a disadvantage the other cases pending with these divisions? I guess that's one downside.
It may. That's why they created the special court in the Arab Plunder case. A separate division for it. But at the time of Arab, there were only 3 divisions. Now you have 5. I am not familiar with the docket of the Sandigan Bayan as far as how many cases the divisions are handling.
Do you have any specific ideas about how to improve the processing of cases or the decisions being reached in cases?
Well, I have a number of them. In the Office of the Ombudsman, they have an additional layer of investigation before the preliminary investigation. They have a fact-finding office, and supposedly they conduct fact-finding before the preliminary investigation. In the Department of Justice, there's no such process of fact-finding. So when the case is brought to the DOJ, they simply conduct the preliminary investigation, then file it or dismiss it. It has proven to be a cause of some delay in the ombudsman that goes through the fact-finding. And in my experience at least, the fact-finding officials generally tend to be rubber stamps. So you don't exactly, they're there to really conduct a thorough field investigation. But the good investigators are no longer in the Office of the Ombudsman. During the time of Ombudsman Marcelo, he had really good people there. Field investigators, lawyers, prosecutors, he had very good people. But when he left, many of those, particularly in the field investigation, also left.
So they're depleted.
So that's one. Frankly, I don't see the purpose for having the field investigation office. I don't think it adds any value to what they're doing. And it just causes delay, and there's a lot of other issues. There are also reports about corruption. I mean, these are just reports, but that should be looked into as well. The more generally in our legal system, the more layers you have, then the more possibilities for corruption also.
The more entry points for corruption. But I just like to pursue that point, because if it's possible for prosecutors to be corrupt because of various temptations, who can check on them? Who prosecutes? Who can
Especially
prosecute
if they
the
come from the
prosecutors?
office of the ombudsman.
Yeah.
I'm not sure. The ombudsman, of course, both as the constitutional ombudsman as the head of office, is the one who should take action. Anyone who has evidence of them committing bribery and stuff should come forward and file cases. It's that you see.
File cases with.
Well, it will have to be with the office of the ombudsman. The problem of accountability is one shared both by the judiciary and the prosecution service. In the judiciary, there is a real legal obstacle. The ombudsman cannot investigate judges. There's a case, a 1993 case, Maceda versus Vasquez, where the Supreme Court said, Ombudsman, you cannot investigate any judge unless and until we have investigated that judge administratively. So, kung malakas ka sa Supreme Court, either natutulog lang yung kaso mo or the case doesn't, or you get exonerated. And the ombudsman has to wait. And if you're exonerated, what will be their basis for prosecuting you? That's why if ask people how many judges have been convicted of bribery or any crimes. I don't know of any. Man, there are judges who are removed, but that's it. So that means if I'm a judge and I want to be corrupt, all I can say, anyway, the worst that can happen is I'm not going to go to jail, I'll just be taken out.
Kumita na ako.
Okay na yun. Although the prosecution does not have a similar ruling that they can hide behind, the fact that they belong to the ombudsman's office and the fact that you have to file a complaint against them before the same office, of course, makes it difficult to hold them accountable.
Just a last point. This was mentioned recently. There is also concern about judicial independence because of the budget of the judiciary. It's still the executive and the legislative branches of government that ultimately decide on how much they get. Is there a way out of this, or is this something that's given and they just have to live with it?
To a certain extent, it's something they have to live with. But I think that there's still a lot of things that the judiciary can do to make. They can't make sure, but at least to provide the situation where the Congress will have to give them the budget they need. Our Chief Justice will be sitting in that position for a very long time, so I think she would be in a very good position to do that and to find ways to influence the Congress to really give the budget that we need. You know, the biggest problem that we have in the judiciary, 1/3 of our courts are vacant. We have no judges. The 27% of our trial courts have no judges. So how can you expect us to have speedy cases when if you have a hospital which is operating like that has only 70 doctors but it needs 100 and every day you have new patients, that hospital will end up collapsing on its own weight. And that is what is happening to our judiciary.
Okay, thank you very much. I don't know if this is depressing or
Well, not to me, because I know it. Siguro to you.
We've been talking to human rights lawyer Chel Jokno on the future of the Plunder cases against the senators, the three senators, Juan Ponce Enrile, Revilla, and Estrada, and businesswoman Janet Napoles. Thank you very much for joining us.